Welcome, KSLU Law students, to this Academic Explainer. Today, we are breaking down exactly how to structure a maximum mark answer for the 16-mark essay question on partnership liability under the Indian Partnership Act, 1932. Right? Let's get straight to it. Pay close attention to me because how you structure this answer is exactly how the evaluator is going to grade you. We'll be relying entirely on the structured text and statutory language, so keep your notebooks ready.
Note down these 5 exact headings immediately. 1. Introduction to mutual agency. 2. Scope of implied authority. 3. Restrictions on implied authority. 4. The doctrine of holding out. And 5. Firm liability and exceptions. Make no mistake, this sequence forms the mandatory skeletal blueprint for a perfect KSLU exam script.
Heading number 1. Introduction to mutual agency. Open your exam answer script with this exact heading written in capital letters. Let's read the provision. Section 19, Mutual Agency. Under the Indian Partnership Act 1932, every partner is both a principal and an agent of the firm, governing third-party relations. You absolutely must explain to the evaluator that this mutual agency is the bedrock of third-party relations. You see, every time a partner acts in the usual course of business, they are binding the firm as a principal, but they're also acting as an agent for all the other partners. Writing this out clearly right at the start secures your crucial introductory marks.
Underline this second heading on your paper. 2. Scope of implied authority.
Let's read Section 19, subsection 1, acts binding the firm. A partner has implied authority to buy and sell goods on behalf of firm, receive payments and issue receipts, enter into contracts, engage employees, and borrow money, specifically in trading firms. Crucially, as noted at the bottom, these must be in the firm's name and ordinary course of business. Now listen carefully to me. Do not condense this list. Reproduce all these bullet points verbatim to secure your full marks for Section 19.1. The evaluator is checking your precise memory of the statute, so don't take shortcuts here.
We now arrive at a critical juncture. Case law, Mercantile Credit Co. Limited versus Garrod. In your answer booklet, I want you to draw a separate, distinct box around this case name to immediately capture the KSLU evaluator's attention. Let's break down the brief facts you must detail. A partner in a garage business, which was primarily for repairing cars, sold a car to a finance company without the other partner's knowledge. Now, the internal partnership agreement strictly forbade selling cars. However, selling cars is an act typical of a garage business. So, what was the final ratio decidendi, the verdict of the court? The court held that the firm was indeed bound. Why? Because the act fell within the partner's apparent or implied authority from the perspective of an outsider. The absolute relevance of this case to Section 19 is that an internal restriction between partners doesn't defeat a third party's right so long as the act is in the ordinary course of business. Explain this case clearly, and you will secure those high marks.
Moving on to heading number 3, Restrictions on implied authority.
Let's look at the limits. Section 19, subsection 2. No implied authority to submit disputes to arbitration, open bank account in personal name, compromise claims or withdraw suits, admit liability in suits, transfer immovable property, and enter into partnership on behalf of firm. These specific acts legally demand express authority from all partners. There is absolutely no gray area here. You must memorize this list flawlessly. Writing this correctly is exactly what differentiates a first-class student from the rest of the pack.
Next, heading number 4, the doctrine of holding out.
KSLU evaluators specifically look for this legal doctrine when marking 16-mark-long essay answers. Let's read the provision. Section 28, Doctrine of holding out. A person who represents himself as a partner becomes liable as a partner to third parties. Let's dissect this legalese for a moment. If you knowingly permit yourself to be represented as a partner in a firm and a third party gives credit to the firm on the faith of that representation, you are strictly liable to that third party. You can't turn around later and claim you weren't actually a partner and didn't sign the agreement. Your representation alone creates strict liability.
To prove you understand holding out, you need this exact precedent. Case law, Scarf v. Jardine. Underline this case name prominently on your paper. Here are the brief facts you need to write down. Scarf and Rogers were partners. Scarf retired, and a new person, Beach, joined Rogers. However, no public notice of Scarf's retirement was ever given. Jardine, an old supplier, supplied goods firmly believing Scarf was still a partner. The final verdict established that Scarf was strictly liable for holding out. Why? Because he failed to give public notice, thereby allowing himself to be represented as a continuing partner. Exactly why does this cement Section 28? Because it perfectly illustrates that liability under holding out rests on the principle of estoppel. You must explain this connection clearly in your answer script. Transitioning to our final segment, Heading 5, Firm Liability and Exceptions.
Let's read across the columns. Under statutory Section 25, the type of liability is contracts, and the rule is firm bound by contracts made within authority. Under Section 26, the liability is torts, and the rule is firm liable for wrongful acts in course of business. Under Section 27, the liability is misapplication, and the rule is firm liable if partner misuses money received. Framing joint and several liability in this structured format acts as a brilliant mental cheat sheet for exam recall. Draw this exact table in your exam. It makes grading incredibly easy for the examiner and truly showcases your organized legal thinking.
Now look at the statutory exceptions. When firm is not bound, partner acts outside authority, act is not in usual course of business, third party knows of the lack of authority. I advise all my students that concluding your substantive argument with these exact exceptions proves absolute mastery to the examiner. You're showing them not just the rule, but the precise legal boundaries of the rule.
Finally, we reach our conclusion. I will read the final quote. The relationship between partners and third parties ensures smooth business transactions while protecting third parties acting in good faith. You see, mutual agency anchors the entire law of partnership. It's the engine that allows commerce to function efficiently, but it hinges entirely on trust. So, I'll leave you with a final, provocative exam prep question to ponder as you review your notes. If good faith is absent, does the shield of mutual agency completely shatter? Keep that legal philosophy in mind as you prepare. Memorize this structure, apply these case laws diligently, and go ace that KSLU exam.